Good afternoon. Happy Tuesday. We are here with Matt Grumbling. He's our patent attorney that's been doing an awesome series for you. And right now we're right in the middle of the accessibility series. Today he's going to be talking about accessibility audits and really teach you how to vaccinate your business against the ADA lawsuit virus. So this should be a really great topic. Last week's topic was awesome. It was really interesting. So hi, Matt.
Hi, Julie. How are you doing?
Good. And we thank you for all this knowledge that you share with us. You don't know what you don't know, right?
That's correct. Yeah. And there are always holes in people's in our knowledge, so it's good to fill those in. So you want me to take over here?
Absolutely. Go for it.
So I'll get
Thank you.
I'll get cracking here. A little housekeeping, move a couple things out of the way. So again, my name is Matt Grumbling. There's my full name. I'm Matt at ntiplaw.com. That stands for Nguyen Tarbit LLC. We do mostly patent and trademark law, but I've been getting into some work on accessibility issues because it tends to blend in with the internet issues that come up in our legal practice. So today I'm going to be talking a little bit more in depth about audits. I think I've mentioned them before, and I've subtitled. I almost forgot to put the subtitle in here until Julie reminded me. And I thought it was clever at the time. Now I'm starting to think maybe it was, it's maybe a little bit of a raw nerve amongst a lot of us now. Yeah, the idea here is, at some point to be sort of proactive. So let's just kind of kick this off here. The topics I'm going to cover today, I'm going to do a bit of an ADA refresher. I think that it helps to have that foundation when we start to talk about audits. I'm going to talk about a little bit of the motivation for doing an audit, and then break it kind of into the two different types of audits, or they're kind of basically two different spaces. There's a physical reality space, and then there's sort of this web space that and more business is being done on the web. I think, with COVID-19, so many of us have been locked away in our houses. We haven't been going out to eat, but we've been ordering things from, say, Uber Eats or DoorDash or something like that. Or you've been ordering a lot more pizza from Pizza Hut or Papa John's if you're in our family. So there seems to be a generational divide there. My wife and I are still ordering pizza or whatever the pizza delivery guys offer, but my daughter is more into the DoorDash or Uber Eats, something like that. In any case, those websites also come under the ADA, somewhat surprisingly. So we'll kind of move along with this. And I say somewhat surprisingly. Well, we'll talk about that as we go along here. So here's our ADA refresher. The ADA is an Equal Opportunity Act. I think that's important to keep in mind when you're looking at this. Why is that important? Well, it was modeled after the Civil Rights Act of 1967, and it's classified by these types of laws are classified by the Supreme Court and by the lower courts as being a remedial statute. And what does that mean? Well, a remedial statute is a statute that is adopted to remedy some problem. There's a perceived societal ill, and Congress wants to fix it. Now, generally speaking, there are two ways that they go about addressing problems. The problem might be one of civil rights, something like an equal protection problem, or it might be a problem of inefficient access to commerce. And I think really when you look at a lot of the Civil Rights Act, some of it was under the Civil War amendments, 13th, 14th, 15th Amendment. But some of it was actually justified by Congress under the Commerce Clause of the Constitution. The Commerce Clause actually, of course, it predates the the amendments, and it gets a pretty wide berth, or at least it has since a famous case called Wickard v. Filburn was decided by the Supreme Court. It has, and Congress has what they call plenary authority to regulate interstate commerce. And what constitutes interstate commerce has become a very, it's a painting with a very broad brush. So you may not think that your business affects interstate commerce, but if it has over 15 employees, the Congress would like to let you know that it does affect interstate commerce. So remedial statutes, because they're adopted to remedy a particular situation, they tend to be interpreted broadly. And you will see that as we go through. We've seen this in the last few sessions. The ADA in some ways looks like because of the action that the Justice Department has taken in enforcing it, it looks like it really should affect only physical access to public spaces, to public accommodations. Well, in the internet age, courts have looked to other sources of information on what constitutes equal access under the law. So, and we'll talk about that a little bit more. We've talked about in some previous sessions. So, this bullet point basically makes that point that the courts often fill gaps in the law, or apparent gaps, with non-governmental standards. And so you need to be aware of those non-governmental standards. They tend to be broader than the standards that are adopted by the federal agencies. So the whole point of the ADA is that it protects those who have a disability, have a history or record of disability, or perceived by others as having a disability. So again, it's a pretty broad group of individuals. The intention here, one of the narrowing intentions, was that it covered people who have permanent disabilities. So why is that important? It's probably not from an auditing standpoint, but it is important probably from a lawsuit standpoint. But I'm not going to go much into why that's important. The important thing is, if you have a situation in your public accommodation or on your website that is reasonably remediable, then you need to do that. And the law doesn't really brook too many excuses. So a disability is defined pretty broadly, but it's a physical or mental impairment that substantially limits one or more major life activities. So again, it's pretty broad, not terribly narrow, but it is narrower. I think you'll see, and as we've seen in previous discussions, than some of the non-governmental agencies' definitions of an impairment. So the regulations, physical places of accommodations are covered by DOJ regulations, and these are helpful because they sort of provide you a safe harbor. If you adhere to the DOJ established regulations, you're in pretty good shape. And we've seen before that there are the 2010 standards for accessible design, and those they're very technical. There are a lot of different parts to them, but they are fairly easy to follow if you're if you're in the construction business and you're used to following municipal codes on everything from, plugs and how many plugs do you need, electrical sockets or outlets that you need in a room, or how many, how many lights do you need, how many smoke detectors do you need in the house, things like that. You can probably follow these standards for accessible design, and many of them may have already been incorporated into local municipal codes, which would make it even easier. It gets a little tricky is when you've got a building that was built either before these standards went into effect, or they and of course the ADA has been in effect since 1990, so it'd be an older building, but there are buildings that older than 1990 out there. Trying to bring them into spec can be expensive and difficult. There are virtual places of public accommodations on the internet. Most of these are internet sales sites, but some of them are points of access for videos or audio podcasts and things like that. The Department of Justice has not established regulations. And you might think, well, that means that there are no regulations. Well, sorry. The courts have filled that gap by applying the World Wide Web Consortium's Web Content Accessibility Guidelines, WCAG. And none of that's terribly pretty. I think I'll just refer to them as the guidelines from here on out, but that's the WCAG are the guidelines that I'm referring to when I'm talking about the internet. There are also state laws that fill the gap. There's California's UNRU Act and New York's Human Rights Law, and there may be others. Your local, various local governments may chime in here, and each one of them they have a little bit different take on it. And even if they don't, they may apply a common law standard that is very close to California's and New York's. So you may find that even though there's no particular law on the books, there may be a broad civil rights law that they might apply, taking notice of, say, California's application of the UNRU Act, something like that. So these are things you have to keep an eye on. So I thought I would go through a little bit about what the mechanics are if let's say you have a complaint filed against you, or you want to file a complaint. The complaint first, so there are two ways to go basically. You can have a complaint that's filed with the Department of Justice, or you can just go straight to court. So let's say you file with the Department of Justice. One advantage there is you really don't need a lawyer to do this. You can just go to the DOJ's website, print out their form, fill it out. Maybe you can fill it out online, I don't know. You put in the particulars for it, and then you submit it to the DOJ. The Department of Justice will then decide whether or not to investigate. They may look at it, and they may look at your complaint, and they may come back with more questions. They may ask for a few more details, and if providing that you answer, if it looks like this is a significant enough violation, or if the facts that you've alleged are seem to be in line with the protections offered by the ADA, then they will decide or not decide, one way or the other, to investigate. If they have an investigation, they may kick it over to mediation. You can choose that as a complainant, and or in agreement with the person you're complaining against. This might be the best way for everybody to get to the point. I mean, let's say you go to your local sandwich shop, and you don't really have any ill will toward them, and you're really not looking for a big payday. You just want to be able to get in the front door, and you find that's difficult because you're wheelchair bound, or something like, or you have a hard time getting your walker over the front stoop or something like that. Or once you get in there, you have a hard time accessing the bathroom or, whatever. You know, a mediation can be a nice way to, we call it alternative dispute resolution on ADR. Is a nice ADR way to clean things up without anybody spending all that money on lawyers. You can now, the DOJ, if mediation doesn't work, then can sue in civil court. And basically, it's the DOJ stands in the shoes of the individual complainant, and they might, you never know, DOJ might find more violations than just the ones that were initially complained of, and so the DOJ enforcement could be pretty severe. So here's an idea, and this is a ballpark of what you could end up facing. You can end up facing civil penalties of $50,000 for a first violation and $100,000 for subsequent violations. So, that's a good chunk of money. I wish I could tell you that that's the worst it could possibly get for you, but it's not. And I'll talk a little bit more about that as we talk about a complaint filed in court directly by a complainant. Now, of course, the complainant would have to have a lawyer or represent him or herself in court, which kind of it is not very likely. It's much more likely that they'll have a lawyer, and the lawyer will probably be pretty well versed in this kind of litigation, probably have done a lot of it, and probably, bases most of the lawyer's livelihood on this kind of lawsuit. Depending on how many people might have been affected, this could be titled a class action. So you could be up against, and that should sound scary, because then, the judgments can get rather large, because you'd be facing a really, really large number of plaintiffs. And the whole idea of a class action is to bundle together the complaints of a whole bunch of people whose individual complaints might not amount to much, but all together, it adds up to a hefty drain on the economy. So the damages vary. They may be very large. They can outstrip that $50,000 or $100,000 with the DOJ enforcement by a lot. Not to scare you too much, because I think that if you're just starting out, or you've got a mom and pop shop or something like that, you're not very likely to get hit with really super huge damages awards. Most of the really scary ones are against companies that frankly should know better. But there's been some pretty big judgments and pretty big settlements for companies, against companies that you would think that they would be sophisticated enough not to have these problems, but they do, and it's been especially true in the internet side. Again, state laws may also be applied, and so if you are if you're sued in state court, you may end up having to answer to those charges as well. The big one here is attorney's fees. So one of the inducements for lawyers to get involved in these kinds of suits is the award of attorney's fees. Now, the American rule is generally that each side pays its own attorney fees. And that's almost always the case, except where the law provides otherwise. And this is one of those cases where the attorney's fees may be shifted much more easily to the defendant the plaintiff. Now, if it turns out to be a frivolous claim, each side is going to end up paying their own costs. But if it's a meritorious claim, then in other words, let's say you're the defendant, you're the shop owner, you're the internet site operator, and you get hit with a big judgment, you may end up getting attorney fees on top of that. And so that's another caution. All of this is to say that you probably don't want to be on the wrong end of an ADA complaint if you can avoid it. So that brings us to why we want to audit. Why do we want to audit? Well, you want to be proactive and avoid ADA complaints if possible. And my impression, having done some research on this, is that the plaintiffs in these cases tend to go after low-hanging fruit. They don't, there are something like maybe 10 hotspots in every business that tend to attract the vast majority of lawsuits. And even though if you get down in the weeds, there are an awful lot of ways that you can mess up. The fact of the matter is that the plaintiffs aren't terribly creative. They don't have to be. They just wheel up in their wheelchair. They wheel through your parking lot. They find that they have a hard time getting from their car to the ramp because the parking lot's too steep. They have a hard time getting up the ramp because the ramp is too steep. They have a hard time getting in the door because the door isn't in compliance with the ADA. They have a hard time reaching things that they're supposed to be able to reach within the establishment because they're not placed within arm's reach, and they don't comply with the technical specs. They don't have to spend more than 20 minutes wheeling through your establishment to figure out what is wrong, and then they wheel into your bathroom if you have one, and it's fairly easy for them to figure out what they have accessibility problems with, and they can take a tape measure and they can measure whether you're in compliance or not. They probably have about 10 things on their checklist, not even a complete audit, and then they ask to speak to the person in charge, the manager, and they lodge a complaint, and 2 weeks later they filed a complaint in district court, and then they wheel their wheelchair off to the next place, and you can complain about that, but the flip side of it is that it seems predatory on the one hand, but on the other hand, first off, the law gives incentives for lawyers to engage in these kinds of practices, and secondly, it's been the law since 1990, so we should all pretty much be in compliance at this point. So you want to be proactive. You want to avoid ADA complaints. You want to spot and correct the most common causes of ADA complaints, straight up. Go through those top 10 and just knock them off your punch out list, and just get them out of the way. You want to document your compliance. Say, your auditor may go through let's say your parking lot, and carefully measure the grade of your parking lot and find that it's in compliance. Any ramps, check those, and just document each of those points of compliance. So if you do get a complaint, you can quickly answer and say, no, those things are all in compliance. There must be something wrong with the at least you've got something. You can document that you've checked, you are in compliance. If you're slightly out of compliance now, it's much easier to argue that you shouldn't have damages, that that just a remediation should be enough, etc. If you find that let's say it's an older building and it's just not in compliance, develop a remediation plan so that you can show good bona fide attempts to fix the problems. And if you have that, a lot of times courts will look at that and go, okay, yeah, we agree with your remediation plan. That's what you should do. And, send you off with a, pat on the head and a glass of water and say, well, we'll check on you in 6 months and see how you're doing with that. But, maybe you won't get hit with a really big damages assessment. So, it helps you to mitigate damages under ADA complaints because it shows a good sense of goodwill. It documents compliance with standards, and I guess that's the point is, once you've got a complaint filed, it's a little late, but it's not, all is not lost. You can document that you've complied with certain standards, and then you can, again, correct deficiencies and develop a remediation plan after the fact. Now, as you can tell, if you can't, my bias here is toward getting this done before you open your doors, or if your doors are open before you get hit with a complaint, because afterwards, it's always harder to clean up, right? So, let's look at an ADA. What are some of the problems with ADA complaints? Well, they distract your attention from your main business. They cause bad publicity for your business. It can be very expensive. You can get, damages. Of course, there's time pressure to remediate violations, and there are attorney fees. And that, under that time pressure to remediate violations, if you let's say you do an audit today, and you find you've got 10 things on your list, 5 are relatively easy to kick out, and you can get rid of those for under $500. Now you've got 5 more things, and let's say one is, just to make it easy, one is $1,000, one is $2,000, one is $3,000. Then you've got a $5,000 item and a $10,000 item. Well, you can prioritize those and start chipping away at those. You can budget for them. You can build them into a timeline so that they don't all come on your head at once. And that is way better than getting a 6-month injunction saying you need to adopt all of these remediations within the next 6 months, or we're going to hit you with damages or worse. So, when I say time pressure to remediate violations, I'm just telling you that, the court can apply a really tight timeline for you to fix things. Whereas if you haven't, if you can do this on your own time, maybe, first off, you can budget for it. Secondly, maybe you can find a contractor who will do the $10,000 job together with the $5,000 job for $10,000 or something like that. Just save yourself some money, and maybe do it in a time when when the economy isn't just screaming along gangbusters, or maybe one of those building slumps. You can find some contractors who can do the work for cheaper than you can when there's a building boom going on. So those are things to keep in mind. And as Julia said at the beginning, you don't know what you don't know. So you might look at your place of business and think, hey, this is great. This is all, state-of-the-art, modern, and the builder I use, I really trust them, and all this other stuff. Yeah, but you don't know what you don't know. And, having somebody who concentrates on this kind of thing, they can spend a couple $1,000 really giving your business the 3 times over. And what you'll find is you have more violations than you think you do. And many of them are easily remediable. And you don't really have to spend a lot of money. But defending yourself from a lawsuit will cost you a lot of money. So, anyhow, it's best to avoid problems and the expense of an ADA complaint. You don't need the headaches. You don't need the bad publicity. You don't need the expense. So let's talk a little bit about a physical audit. And the challenge I have here is talking about these things giving you something more than I gave you in the last few weeks, but not getting too much down in the weeds because that gets really boring really fast. So just a reminder, the ADA Title III covers public accommodations. These are the standards, the 2010 ADA standards. They haven't changed much. There's also a nice guidance document that you can get at ada.gov. This covers all new construction alterations after March 15, 2012. That's 9 years ago. So, a lot of even older buildings probably have had alterations since then. So let's talk about some big ones. And I'm just going to hit big ones. These are the ones I know about that get hit the most. One is parking. Parking is, the grade of your parking area, the grade of the ramps coming out of the parking area and onto the sidewalk, and then if necessary into the establishment. You might think, well, I don't need to worry about all that stuff. The construction company, put them in right. I'm sure they did well. Better, be safe than sorry, right? Ingress and egress, and I've mentioned in one of the previous things, there's a requirement for a kick plate on the door. So the doors have to be easily openable by somebody who is in a wheelchair. Restrooms are a huge problem. There are so many different ways that you can go wrong in the restroom. There are some very technical requirements for the restrooms. Things like just the height of the vanities, the height of the lavatory, the height of any shelves and hooks that you might provide, handholds, turning space, the height of the commodes and the water closets, and a big one is the height of the mirror. If a mirror is provided, it has all these very technical requirements for it. You would think, well, I'm just being nice providing a mirror. I don't have to provide a mirror. That's right, you don't. So if you ever go into a bathroom at let's say your favorite burger joint, and you notice the mirrors have been removed, you might think vandalism. That might be true, but it might just be that they weren't able to bring them into spec with the ADA, so they just took them out. Restaurants especially have a lot of seating issues, and you need to be aware of those. And then just any services. Think about if you're in a restaurant and there are separate services that need to be accessed. They need to be accessible. They all need to be accessible to everybody. So what should the physical audit include? Well, they should inspect every part of the store that is accessible to the public. And I'm going to leave out the parts that aren't accessible to the public. Those come under different standards. But for the ADA, well, it's mostly, the part that is the public accommodation. They need to look at every part of that store, and they need to have a checklist. If they don't have a checklist, what are they doing there? Just having somebody walk around and go, oh, it looks okay to me. That's not good. They need to have a checklist. They should have specs for every physical part of the store that is important for access. They should generate a report at the end. It should be a fairly detailed report. If it's not several pages, what did they do? The checklist should provide the backbone for the report, and you should be able to look at their checklist and, even if they have nothing to report, if they have no violations to report, they should say, we looked at this, we looked at this, we looked at this, everything's in spec. But the report should note any violations, and then give you the standard that needs to be met. And they can provide you the citation to the guidelines, but they should also they should also kind of explain it in plain English so that you can understand it and implement it. You know, explain it to your contractor who's going to have to do the work to bring it in spec. It'd be great if they had a picture. You know, anybody these days can go around with their cell phone and click off a bunch of photos. And they should have a photo of the feature that is in violation so you can see exactly what the problem is. If you have a sign up for your bathroom that is not in specification, they should have a picture of what's of your bathroom door with the, you know, with that sign on it, and then it should say, this is what it should look like, and maybe even give you an example of what it should look like. And that's the last part is just the suggested remediation. What should you do to fix it? And there may be more than one suggestion for the remediation. Like for a mirror, it might be, you know, put in a mirror that's within spec or take the mirror out. So for access to the building, you know, these are some of the things, these are some big things. Sufficient wheelchair accessible parking, grade of the parking surface, wheelchair accessible ramps, proper grade, and, you know, and I think there's some requirements for non-stick surfaces, or non-slip surfaces, things like that. Kick plates on doors, elevators where it's necessary to access you know, an above grade a part of the structure. Wheelchair accessible seating. There needs to be a certain percentage. I don't recall what it is, but it needs to be in each type of seating. So if you've got a bar, if you've got separate tables and then booths and then maybe outdoor seating, each of those has to be has to have a certain percentage of wheelchair accessible seating. Reach, you know, there are a variety of things, cash register, condiments, drinks, utensils, and trash. You know, it's in a lot of fast food places, you have to serve yourself your own drinks. So those need to be, you know, not only does the dispenser have to be reachable, so do the cups and the lids and the straws. And if you know, if you're putting condiments out there that are accessible to people who aren't wheelchair bound, then they need to be accessible to everybody. The bathroom is, like I said, the bathroom is one of the biggest violations. It's like you know, it's sort of the heart of darkness for these ADA suits. You need to really spend some time in there. You know, appropriate signage, turning space, accessible water closets, handholds, mirror, lavatory, hooks, shelves, etc. All of these things they have requirements for how high they are, how much space you have underneath them so that you can slide a wheelchair up underneath them, space to turn around, handholds to move from the, you know, from the wheelchair onto the commode and back off again, and things like that. So you know, that's the, you know, this is kind of just an example, but you know, you can see here there's an awful lot to mess up. I mean, who would have thought that signage would be such a big deal? But if it doesn't meet certain specifications, it's technically in violation. And here's the thing is, you know, you might have somebody come into your bathroom and they might just measure your mirror and find that it's too high and file a complaint with the DOJ. DOJ might come out and do a full audit and find that, you know, all these things are off, and then you've got a real problem on your hands. So better for you to do the audit yourself beforehand, and things just get more expensive the longer you wait to do them. So website audits are a relatively new thing, but they're becoming increasingly common. The trend I've seen so far is the bigger you are, the more attention you're going to draw. So obviously your Amazons, your Yahoos, Netflix, they're the low-hanging fruit for now, because a person with a you know, reduced vision can go on their website and pretty quickly tell whether whether it's amenable to increasing the size of the font and still being able to read everything that's on the page. That's one thing that they check for. Or, is it compatible with their web reader, something that reads it out to them, or something that actually gives them a tactile braille representation of what's on the page. These things are fairly easy to check, and so of course right now they're going after the bigger providers because they have the deeper pockets. That doesn't mean that you're not vulnerable. It just means you're lucky so far. So it's good to think ahead, and aside from the liability issues, there's also just the fact that you want your market to be as broad as you can have it. So if there are things that you can do, technologically to broaden your market, you'd want to do that. And so these website standards, they're not governmental standards. They were put together by the World Wide Web Consortium, and they have put together the Web Content Accessibility Guidelines. Courts have been applying them because there's the Department of Justice just hasn't kept up with the times, surprisingly. I mean, it took the federal government how many years to adopt the ADA in the first place, and then and since then, DOJ's had over 30 years to adopt. Well, and since certain vice president invented the internet, we've had at least 20 years to adopt these accessibility guidelines, and DOJ has yet to do it. They promulgated some intention of rulemaking several years ago, and they haven't done it yet. Congress was thinking about doing something last year, but they dropped the ball. So now the courts have to fill in the gaps. So the current iteration of the guidelines is WCAG 2.1. It's been in force since 2018. What it does is it kind of expands on the previous version of the WCAG. You can tell these are computer individuals doing this because they use that, kind of main number dot, extension type of numbering in order to differentiate their various versions. But you can see there's 10 years of time that's lapsed between 2008 and 2018. And so, honestly, even though it's been a few years since these came out, I think if you comply with them now, you'll probably be in compliance for a pretty good long time. So one of the interesting things I found was that these editors of the guidelines, they come from some pretty big corporations, and then there's one from the World Wide Web Consortium itself. And you can find these technical specifications at this website down here. I won't read it off for you. So the guidelines are supposed to improve accessibility for those with blindness and low vision, deafness and hearing loss, limited movement, speech disabilities, photosensitivity, learning disabilities, and cognitive limitations. That's an awful lot of provisions there, and it's also supposed to be generalizable to desktops, laptops, tablets, and mobile devices. So I would say that most of the suits so far that I've seen have been filed by people with impaired eyesight, and that shouldn't be too surprising, given that the internet is such a historically has been such a vision-driven type of medium, that those would be most of the lawsuits. Again, I think what we're seeing is we're probably seeing the beginning of this trend, and we may see these things evening out over time. We may see more complaints by people who are hearing impaired, who want to see transcripts of podcasts, for instance. I did see one lawsuit on that. So there are success criteria. These are supposed to be testable statements that are not technology specific. And they might have some technology specific examples to illustrate them, and you can use those. You can use those as kind of like a safe harbor, but it doesn't matter what technology you use as long as you get to a success by these testable statements. Okay. I kind of just reset what I said up there. So what should the audit do? Well, again, should it inspect every part of the website that is accessible to the public. You don't need to have, they don't have to look at your back end. They just need to look at the forward-facing part of your website. And they should have a checklist of the standards again. And you should be able to look at what they went through. What particularly did they do for each of the standards that's there? Which software did they use to try to read the text off of your website? What tests did they perform? Things like that. There should be a report. Again, it should have every noted violation, whatever the standard was that was supposed to be met, and then a screenshot and or a description of the feature that is in violation. So this is very much, in a very real sense, it's almost like walking into your store and, trying to wheel the wheelchair around. Well, here, for the most part, they're probably going to be trying to get around your website using one of the many available web readers and applying that technology. And you're going to want to make sure that it's, your website can be accessed. Now, that's not the only technology, the reasonably accessible technology. In some cases, for instance, like for instance, people my age, you might just get, you might need to have the possibility of expanding the text, increasing the size of the font without changing the content, without changing the layout to the point where it's indecipherable, right? So that's another test. So you can see two different tests for people who have, poor or reduced or no eyesight. So these things need to be terribly robust. You can't just go in there and say, oh, well, it works fine on my from my phone here, so it's great. Well, how does that scale to your to your tablet? How does that scale to your computer, your laptop, your desktop? How does it look under those situations? Another thing is color blindness, right? So there's a standard for meeting color blindness. There are times when you might have a pie chart that has green and blue on it. If you have individuals out there who aren't able to see, they aren't able to discern green from blue, that's a problem. You might either need to change the color that's there, or you may need to provide some sort of a text-based description of it that is readable by a text reader, that is readable by somebody with diminished eyesight. So that's pretty much the end of my presentation there. Sorry about that little jerk there at the end. I don't know if we have any questions from folks who are online, or I can hand this back over to you now.
And just so everyone knows, these are recorded and they're saved on our YouTube channel, City of Surprise Economic Development YouTube channel. So you can go back. If you've missed any of the series, I highly recommend that you go back and watch these. today's was great. Last week's was super informative, and, you don't know what you don't know. So it's better to kind of have an idea before you get yourself in some trouble. So thank you, Matt. And we will see you next Tuesday, same time, same place. And we'll be talking about accessibility remediation. And that will be the end of the accessibility series.
Right.
So
All right.
we will be coming up with some great topics, but we'll probably just be doing them monthly from now on. So if there's anything that you really want to learn about, or you need more information that you think would be a great webinar, please let us know, and we're happy to see what we can do for you.
Right. Thanks, Julie.
Well, thank you. You have a wonderful day, and we'll see you next week.
Too. Have a great week.
Okay.
Bye.